Okay, so we've got people starting to roll in. We'll give it a couple minutes until we're.
Okay. How many people registered?
I don't have access to that right
Yeah.
now, but we're getting so many. I mean, we're getting like in the 30s, 40s, 50s because of the Zoom, which is really nice.
Good.
So we've got 14 in already. Welcome, everybody. It's just going to take a couple minutes. We'll get everybody signed in and then we'll get started.
I know there's a filter to make yourself look like a cat or a dog. Is there a filter to make yourself look younger?
I don't know. If you find it, let me know. We had shortly after that video came out, we had a presentation on kind of Zoom technology and litigating in COVID era and through Zoom and everything. It was actually really interesting. And of course, that was a huge topic of discussion was that video. And I've been searching for filters, trying to, in certain settings, make sure I have a good background and everything like that. And I haven't quite found that yet. But if you find one for youth, I mean, let me know.
I actually came down to ADR's offices because I'm a technological ignoramus. And I wanted to make sure somebody was here just in case I mess things up.
That's wise. That's why I had Ian help me because he's been running all of these.
I've gotten the hang of the Zoom mediations, but
yeah, it's definitely interesting stuff. I actually I have a standing desk too, which I got a couple years back because my back is horrible. And it's actually been really helpful in hearings, when I lift it up and I get myself on my feet and, mediations and other things like that. It's not as necessary, but it's been helpful for hearings. So we're all adjusting.
What's going on with the courts when they're going to start jury trials again?
It obviously depends on the county. And San Diego for a while, Judge Alksney was saying no civil jury trials until 2022. But
wow. 2022?
Yeah, she was saying that it's just not going to happen this year, and that we weren't looking until early next year for civil jury. I know that they started bench trials, mostly, I think, all by Zoom. I think they're bringing people in as needed, but I think she just recently updated in the San Diego County website, put something out. Oh, and look, Ian just sent a message that said,
I just saw that.
Yeah,
Alan Brubaker's
doing
his first civil trial.
Yep, with Judge Taylor. So that's where we are.
But that's non-jury.
It is a jury trial, civil jury. So yeah, this is I guess we'll have to have a presentation after that's done, see how everything goes.
I wonder if the jurors are actually there.
I think so. And I think when they started bringing jurors in, they were, usually they only get so many people to respond anyway. And then in COVID, it was just horrible numbers. But, and then so they were looking at using outside facilities that have a little bit more spacing to kind of bring jurors in. And that was the last I heard. I think that was on a presentation a couple months back. So I haven't seen it updated.
Well, I'm so old that I have both my vaccinations.
Good for you. That's lucky.
Past 2 weeks, I'm ready to go out and hug people. But nobody seems to want to hug.
That's lucky. I'm on the wait list. I'm basically, they've got my phone number and I'll get a text if anybody doesn't show up for their appointment because
it's CVS.
Yeah. Yep. And if I get a text, I have 15 minutes to respond and 2 hours to get to the vaccination site. That's the only way I'm going to get it. Otherwise, I have to wait until everybody else gets it.
Yeah. In Los Angeles, they have one of their rules is if you have to appear in court regularly, then you're eligible to get it.
Oh, really?
I know some of my son's friends who are in the like the DA's office or the AG's office.
Yeah,
they've gotten it that way.
Sure. Yeah. That makes good sense. All right, let's see. We are just about 2:05. Probably a good time to get started. Got 24 people already in and ready to go, and everybody's got a timeline. So we'll just go ahead and get started, and then people can join as needed. All right, so colleagues, thank you for joining us today for this presentation. Today, we are fortunate enough to have Ray Artiano, who is with us. Ray has over 35 years of practice under his belt, and he's litigated over 750 employment matters successfully tried over 40 cases in both state and federal court on behalf of plaintiffs and defendants. Ray is currently working as a mediator with ADR Services, Inc. in San Diego, and he has experience representing both sides to allow him to evaluate the strengths of all the parties. Ray's areas of expertise include wrongful termination, discrimination claims, harassment, retaliation, pattern and practice under Title VII, ADA discrimination, wage and hour violations, and more. So today we are lucky enough to have Ray here to tell us from the defense end on how to successfully mediate a defense case. So Ray, without further ado, please.
Thank you. And I'm going to share my screen primarily so that I'm just a little box. I want to thank everybody for viewing this. I was somewhat looking forward to a live presentation, but nowadays it's done with Zoom. Everything's done with Zoom, including mediations. I have mediated cases as an attorney for about 35 years. And I've mediated cases as a mediator for a few years now. And I have to say that you learn a lot more being a mediator about how to successfully mediate these cases than you do as a lawyer. Employment cases are different than other cases. And why are they different? There are, of course, many commonalities, especially insofar as monetary issues are concerned. Negotiation tactics are frequently the same, but there are very, very key differences. First one is that this may not be the end of the relationship for the parties. You have an auto accident case, and you generally don't know the other person who's involved in the collision. You have a product liability case. You're not going to encounter these people after the litigation is over or after the mediation is over. For an employment case, especially if you have an existing employee, that's not going to be the case. It's not going to be the end of the relationship. The employee is still going to have to appear at the workplace and interact with his or her coworkers and supervisors and subordinates. Even if the person is no longer an employee, it still may not be the end of the relationship because they may end up with a job in the same field and may still end up interacting with the employees of the employer who they left. Where there is an existing relationship, when you mediate a case, there are many non-monetary tools that are available. We're going to get into this in some detail later on in the presentation, but for instance, many plaintiffs are interested in expunging portions of their file. They may want a letter of reference, something like that. Another difference is that statutory attorney's fees, where they are available, for instance, under FIA, are often very big issue. You oftentimes have attorney's fees that are driving the case, where the real value of the case is minimal, and it's all about the attorney's fees. And finally, and most important, employment cases are very, very personal. They're unlike other cases. The employee who's been either discharged or feels that he or she has been discriminated against or retaliated against feels very, very strongly about their position. The defendant also, especially where intentional discrimination is concerned, is just as vehement about their position. The problem that raises is that in many instances, can you hear me? Am I muted?
It just came back. We lost you for a minute, Ray, but you're back now.
Oh, okay.
I wasn't sure if that was my audio or not, so you're good.
I'm sorry. We were talking about emotions in these cases. In an auto case, parties can understand and accept the fact that there may be a finding of liability. In fact, there may be a police report that finds the defendant responsible for an accident. Even when you have a product liability case, the company, even though they've followed all their procedures, they've complied with all the regulations, federal and state, recognize the fact that there may be a finding of liability. But in the employment setting, the emotions run so high that it makes it very, very difficult to find common ground. But there are ways to find common ground. The other reason why employment cases are different is that for the employer, they may be precedent setting in terms of dealing with other employees. Even where there's a case with, or especially I should say, where there's a case of little merit, they settle the case. All other employees who are similarly situated may be potential plaintiffs down the road. So this is a reason why employment cases are different. How to define a successful mediation? Well, at its most basic level, a successful mediation is getting a case resolved as effectively as possible. And that's especially when the mediation takes place after there's a lot of discovery and the parties are down to the bare bones and they're ready to talk settlement and either settle the case or go to trial. When you go to mediation and you resolve the case, it very rarely involves both parties getting exactly what they want. Before you go to a mediation, you usually vet the case with your client. You you decide what range of payment, whether it's monetary or non-monetary, is established. You then go to the mediation, and it's not very often that, well, it almost never happens that you end up resolving the case for exactly the lowest amount, let's say, that you intended to pay, and the plaintiff gets at least as much as they initially wanted. I actually had a case not too long ago where I met with the plaintiff's lawyer first, and without any prompting, and this should never be done, by the way, on plaintiff side or defense side, they told me that they would be very happy if they could walk away with $50,000 in the case. And then I met with the defense lawyer, and again, the defense lawyer shared with me that he was ready, or they were ready to pay $100,000 to the plaintiff. Needless to say, that case resolved, and both parties got exactly, if not more, than they want. More often, both parties come away satisfied. That's in a case where you've established your range. You may have a target, and you may have what I call a reserve amount, which is your bottom line. What's the most you're going to pay in a given case? And the plaintiff has a bottom line, and they have a range as well. They're not going to take anything less than, let's say, $50,000. They'd like to come away with $100,000. And you mediate the case, and it turns out that the plaintiff ends up getting somewhere in the bottom range of what they want, and the defendant ends up paying somewhere in the middle or the upper range of what they wanted. I don't know if this happens most often, but a successful mediation is also one where both parties are grudgingly satisfied. You set your range, and again, let's say your range is $50,000 to $100,000, and the plaintiff's range is $60,000 to $150,000. In those instances where the defendant has to pay, especially a little bit more than what they considered their bottom line, and the plaintiff has to, or ends up accepting a little bit less than what they thought they were going to accept as a bottom line. That's where both parties walk away grudgingly satisfied. And it's important to remember that even though you establish a target and reserve amount prior to the mediation, that may change. It may change based upon new facts or new cases brought to your attention. May change on a number of different bases, but that target and reserve amount may change during mediation. And one of the things that we're going to talk about is how to get the reserve amount to change from the perspective of the plaintiff's attorney. Preparing for successful mediation. First thing is you have to know when to mediate a case. From the defense standpoint, you have a huge advantage at the outset, because in almost all instances, you will have interviewed all of the key witnesses. Usually, the plaintiff in a case where they're an employee or a former employee has been interviewed by the employer. You have access to all of the key documents of the defendant. So you're in control of most of the facts and the key documents. So even though you may first want to take the plaintiff's deposition before going to the mediation, you have the upper hand. Let me dispel one notion, and that is an offer to mediate a case is not a sign of weakness. I know a lot of people believe that it is, but in my estimation, if you're a defense lawyer and you ask the plaintiff's lawyer if they would like to mediate early on in the case, and plaintiff's lawyer says, fine, that's not a sign of weakness at all. Usually, plaintiff's lawyer will say, well, we can mediate now, but I'm not, don't feel very sanguine about the possibility that the case may settle. Still may be a good time to bring the case to mediation. Sometimes the case is brought to mediation before litigation is filed. One of the reasons why it's important, or why you should consider getting the case to mediation early, is that it's very rare that you'll find a case where your case gets better. There are the rare cases where, for instance, you discover, let's say that the plaintiff has falsified his resume, which you didn't know early on. There's a case, an actual case, where you discover that the plaintiff has filed 6 almost identical cases in a number of different jurisdictions. But usually the case is going to get worse rather than better. It usually gets worse as more documents emerge and more witnesses are deposed. Witnesses can say things that flavor a case and can be very damaging to your defense case. And there's very little outside of preparing as best you can these witnesses that you can do to guard against that. Sometimes cases turn on minor issues. For instance, I had a case once where my client admitted calling the plaintiff a scumbag. And that was, in the jurors' minds, obviously spoke with the jurors afterwards, that was a very, very big issue. So deciding when to mediate a case is obviously up to your discretion. I'd urge you to take the plaintiff's deposition at least before agreeing to mediate. I certainly would want to mediate if I was aware of very, very poor facts and you know that the plaintiff's or the plaintiff's lawyer is not aware of those facts. That's an excellent time to mediate very early on. In order to successfully mediate a case, it's really important that your mediation brief cover the key law and the key facts of the case. It's important that the mediation brief contain key documents, unless of course you want to save certain documents which you think the plaintiff will not have access to, and you want to save that in the event that the case does not settle for trial purposes. I am a believer in sharing all non-confidential information with the other side. Most of the time, the briefs that I receive, the mediation briefs that I receive, if I receive a mediation brief, is labeled confidential. There are two reasons for submitting a mediation brief. One is to educate the mediator on the law and the facts, especially if the mediator isn't conversant with employment law. Because what you want to do is have the plaintiff read the brief, where your ultimate goal is to lower the plaintiff's expectations. Perhaps you'll show the plaintiff why their position and their targets and their reserves are inconsistent with the law and with the fact. It's important also in preparing for a mediation to thoroughly discuss the case with your client, discuss the goals that you want to achieve when you go to mediation. Establish parameters for a settlement. If you haven't discussed it with the client, it becomes much more difficult to structure a good mediation resolution. When you're at the mediation, at this point, you've completely prepared for the mediation. One of the first questions that I think you should consider is, if you have multiple clients, for instance, you have a supervisor, you have the entity itself, the employer, have you complied with California Rule of Professional Responsibility, Section 3310? That's entitled, by the way, Avoiding the Representation of Adverse Interests. And that's the subject of a whole other presentation. But you have to have informed written consent before you represent multiple clients. And there are instances where their goals may actually be different. So make sure that if you're representing multiple clients, that you have written informed consent. Is face-to-face important? Well, sort of a moot issue now. I guess is face-to-face on Zoom important. Mediations have changed a lot. When I first started practicing, it was always the case that there'd be an opening statement by the plaintiff's lawyer, and there'd be an opening statement by the defense lawyer, and there'd be a discussion at the outset before you actually broke up into rooms. It's no longer the rule. Now it's much less likely that you'll actually have a face-to-face meeting with the plaintiff. Whether or not you want that face-to-face, again, this is a Zoom face-to-face, whether or not you actually want that is case dependent. If you have an existing employee and you're trying to craft a resolution for that employee to return to the workplace, then I think it is important in order to allow the plaintiff the ability to vent, allow the plaintiff to explain why he or she feels he or she has been wronged. And it also gives you the opportunity to convey to the plaintiff the reasons why you took the actions that you did, which eventually led to the plaintiff's claim of discrimination or harassment or termination, wrongful termination. Oftentimes the plaintiff is completely unaware of reasons for the actions taken. And it's also important, if you have an existing employee, to be able to discuss options for their return to work. So while it's not the rule, face-to-face with the plaintiff may be productive. You have tools at your disposal in employment cases, which are both monetary and non-monetary. If you have an existing employee, you oftentimes talk about restructuring the plaintiff's job. If you have an employee who has been discharged or is claiming constructive termination, they may very well want records expunged. Plaintiff may bargain for a change in policies, a change in written policies. They may want a change in HR policies that involve procedures for complaining, things like that. It may involve training for the employees or the employer's staff. So you have a lot of non-monetary tools available. By the way, it's important, I think, on discussing the non-monetary tools, to add that it's important for defendant rather, to have a non-disparagement agreement and confidentiality agreement where that is in fact allowed. On monetary issues, what should your starting point be? And the question I get asked a lot is, should your first offer be in the ballpark? Remember, you've gone to the mediation and now you have a range, which includes your target and which includes your bottom line? What should your starting point be? Well, I don't think that your first offer should actually be, quote, in the ballpark. When your first offer is actually in the ballpark, you may immediately create expectations on the part of the plaintiff and plaintiff's lawyer, which present problems for you. Most plaintiffs' lawyers, and I certainly tell the plaintiffs' lawyers, expect low first offers. That doesn't mean that in a case with a potential value of $1 million, that you should be offering $1,000 with the reasoning that, well, plaintiff's lawyer was unrealistic. Their demand was unrealistic, and I think that I'm going to win this case. If you start there, that can do it for the entire mediation. But it's not unreasonable to look at your range and the low range of a case, and then look at the chances of liability and make an offer based upon that. In other words, all right, you lose, but the plaintiff gets the least amount of money that you can think of, and plaintiff only has a 30% chance of winning. That's a lot different than making a $1,000 offer on $1 million case. So what happens is that you continue on with the mediation. You have usually a pretty large monetary gap between the two parties. And you want to bridge that monetary gap. How can you do that as a good defense lawyer? I believe that you can bridge the gap first by changing the plaintiff's view on their bottom line, or by using what I call pressure points. You've submitted your brief. We talked about the importance of a brief. You have to give the plaintiff reason to question the merits of their claims on both liability and damages. There may be a key factual issue which plaintiff is wrong on. Plaintiff's case is based on discrimination, let's say, and one of the key facts is that plaintiff believes that the entire restructuring of the company, which led to his or her termination, was because of the discrimination, or whatever the action was. You know that the decision to restructure was made long before the plaintiff ever voiced any complaint about discrimination. Plaintiff may think that she was replaced by a younger person in an age discrimination case, and you know that not to be the case. These are things that should be shared with the plaintiff's lawyer, and which can actually change their view on the bottom line, change their view about the merits of their case. Plaintiff may be wrong about the viability of certain causes of action. Usually this is dealt with in terms of or with a summary judgment motion or a judgment on the pleadings, but especially early on in a case, it might be important to bring that to the plaintiff's attention. By the way, I can't remember if I mentioned this before, but on the mediation briefs, I don't think that the mediation briefs should be confidential. I think that it's important to let the plaintiff know that why they should reconsider their thinking on the case. So maybe you can show that there's no liability or no individual liability for discrimination or retaliation. Maybe the fact is that there's no liability because the individual who is accused of whatever acts which give rise to the case is not a supervisorial employee. It may be that the employer isn't subject to either a federal or state statute because they did not have the minimum number of employees. Things like this should be brought to the attention of the plaintiff's lawyer. There's also the question of the viability of certain types of damages. Plaintiff may not be aware that they can't recover emotional distress damages on certain causes of action, including wrongful termination based on breach of contract, or that they can't recover punitive damages against a public entity, but can against an employee of a public entity. They may misunderstand the provisions of an employment contract. Again, going to the public entity setting. In a public entity setting, if you have a contract and there's 18 months left on that contract, you're going to be limited to those amounts of damages, and further limited by another cap, which says, notwithstanding, you can't recover more than X amount of damages. Plaintiff has to be made to understand that if attorney's fees are awarded, that might not necessarily be of benefit to her or him. How do you communicate that? Again, you communicate that through the mediation brief. I would recommend, of course, your defense lawyers, but I think that most plaintiffs' lawyers, and I've been on that side as well, will share the briefs with their client. And if in your brief you explain that if attorney's fees are awarded, that's not going to do much for the plaintiff, that may change their view about settlement. You can have cases that go to trial, and you've all been there, and the award is minimal, and the attorney's fees, which have driven the case throughout, are very, very high. The other thing that you can do, and which you should do, which I do not see often enough, is you have to challenge the plaintiff's damage assessment. Plaintiff makes a demand of $500,000. You want to know what that is based upon. Is part of that based upon theory of damages which aren't recoverable, or is the plaintiff placing a ridiculous amount on potential recovery of emotional distress damages? Has plaintiff incorrectly determined that their lost wages are going to amount to X when it should be Y? You have to challenge each and every aspect of the damage assessment. And that's when you're talking to the mediator. You should be asking, I don't understand, what's the basis of their claim for damages? How did they get to $500,000? I think that in terms of bridging the monetary gap, how far you want to go to bridge the gap depends upon the stage of litigation that you're at. In other words, if you're pre-litigation or very, very early on in litigation and you have a mediation, you may not want to bridge the gap to what you feel would be a reasonable amount if you don't think that you're going to settle the case at that time. If you're about to go to trial, and you know this is the time when you are going to either settle the case or get on with it, that's when you want to fully bridge the monetary gap. I am not a big fan of the take it or leave it as a matter of last recourse. You can either take $300,000 or not. If you don't take it, I'm going to file a statutory offer to compromise. I am less in favor even of a, you don't take it today, that money is off the table. You really, when you do that, you're really throwing the gauntlet down to the plaintiff. You can also use pressure points to get the get the plaintiff to reconsider their position and lower their target amounts. One of the ways to do that is to file a motion for summary judgment before the mediation. You file a motion for summary judgment, the plaintiff has to consider what happens if they lose the motion for summary judgment. What happens if the motion for summary judgment turns into a motion for summary adjudication and it's granted on certain causes of action? Plaintiff, by the way, has many more pressure points than to choose from than the defense counsel. They have individual liability, they have punitive damages, they have threat of bad publicity, and so on. So the defense pressure points are more limited, but certainly a motion for summary judgment is an important one. And if you have a motion for summary judgment pending and you're trying to bridge the monetary gap, plaintiff has to understand that if you lose the summary judgment motion, that's not going to inflate your estimate of damages. It's not going to inflate the range. Again, the risks of failing to settle, this has to be communicated somehow to the plaintiff. Plaintiff may be offered $100,000 and other non-monetary compensation, and if he settles the case, attorney's fees aren't very high, costs aren't high if it's early on, but they're basically going to receive, if the plaintiff's lawyer is on a contingency, 2/3 of that less costs. They may go to trial and get $200,000, where $100,000 of the full award has to do with attorney's fees, or at that time, a great deal more in costs have been expended, and even though they get a lot more money through trial, they have not gotten as much as if they had actually settled during the mediation. Can a successful mediation be one without a final resolution? My answer to that is yes, especially if the mediation is early on. You can begin to change the mindset of the plaintiff or the plaintiff's counsel. Sometimes you can identify where further discovery is necessary. You can identify factual and legal disputes. You can put yourself in a position for a statutory offer after the mediation. And remember, the first mediation is not necessarily the last. Many cases end up being resolved after a number of different mediations. And along the same lines, even if you file a summary judgment motion, that can be a very successful tool for you because oftentimes it forces the plaintiff's lawyer to file declarations and other evidence where they overstate, where they are trying to defeat the summary judgment motion and just go a little too far. I can't tell you the number of times that declarations of the plaintiff and witnesses, which were submitted in opposition to a summary judgment motion, were great fodder for cross-examination. Everything that I've said during the course of this presentation about getting the plaintiff to change their mindset also applies to the defense team. You know, if you learn new things, you're advised of new law, don't hesitate to reevaluate your position. And it may very well change the range, your target range, your bottom line range. When I say be honest with the mediator on factual issues, I leave it at that. That doesn't mean that you're going to tell the mediator what your real bottom line is. Too often, as in the example that I gave you, parties will do that, and once they do that, they can't really, they're not really in a position to change their position. Sometimes, and this happens more often with the plaintiffs, you have a recalcitrant client, you need help with the client, and you have to let the mediator know that's the case. So the mediator can speak with the client. You may or may not want to be present when the mediator does that, but that's oftentimes crucial in getting the case settled. And finally, not on this list, but I thought about this a while ago. The release, when you get a resolution in an employment case, it's much more often than not that there will actually be no release that's signed at the time of the mediation. You always would like to have that done. Employment cases sometimes are a little bit more complex, and you want to make sure you comply with 664.6 in terms of the settlement agreement, and you have to include all material terms. And because there are many non-monetary tools that we're talking about, these are generally the subject of negotiation. And if parties can't enumerate all the material terms, it's going to take some time to actually achieve that. So I guess I'll sum up by saying I think that the keys to a successful mediation are in preparation and in being able to change the mindset of the plaintiff's counsel. And I hope that the information that I've imparted has been helpful to you. And if I see that we're just about out of time, but if there are any questions, I'm happy to take those.
All right, great. Does anybody have any questions? You can go ahead and either use the raise your hand feature, or you can type in a message into the chat. We'll hang out here for just a minute. Thank you, Ray. That was very, very helpful and informative. I'm actually curious. I mean, what have you been mediating any employment cases related to COVID, whether it be, you know, people who felt like they were forced to come to work and didn't want to because it was unsafe, or I'm interested. What have you been working on?
I have not handled any COVID-related cases, but I suspect that there are going to be a lot of those.
I do too.
I can see it coming. I can see suits against airlines, suits against establishments, or employers who mandate the vaccine.
Mm-hmm.
So
It's going to be interesting. It's going to be
interesting.
interesting.
There will be a lot of those.
Maybe what we'll have to do is maybe a year from now, when those kind of start to roll in, we'll have to bring you back in for an update on what you're seeing on mediating those types of procedures or those types of matters, because I think it's going to be, it's, you know, what was really interesting was before we had the original stay-at-home order a year ago, I was curious to see how many people would be filing suit because they were still required to show up to work every day, but didn't feel that it was safe based on the science that was coming out at the time. And until there was a stay-at-home order, a lot of people were expected to just show up. And it wasn't until we had that people were able to start working from home if possible. And so I'm really curious to see how that's gonna come out in your scope, in the employment scope.
To be quite frank, I'm not even sure. I've seen different opinions on this. I'm not even sure if HIPAA is waived for purposes of COVID.
Yeah. And that's interesting because that came up. There was a series of cases in hospitals where they were requiring staff members to get the flu shot. And if they didn't get the flu shot, they were required to wear a mask in the hospital at all times during flu season. And they were usually required to have some sort of a bright sticker on their badge, which was essentially like a scarlet letter, right? So some people maybe chose not to get the flu shot for whatever reasons, but some people either had religious exemptions or medical exemptions. And there were a lot of big suits because of that, because it was essentially a HIPAA violation.
Right.
Badge and, you know, mask all the time. Now nobody would think twice about it, right? But
right.
At the time,
I know that most employers are not identifying people if they become infected.
Yeah.
But are communicating with any individuals who may have been in close contact with that person.
Interesting. All right. Well, having no questions, that tells me that all the questions were answered. Everything was very thorough. So Ray, again, I want to thank you so much. And colleagues, I forgot to mention that Ray is a former president of SCDL. And that's a pretty significant chunk on his badge there.
I'm so old that I was actually a lawyer when my partner and some other lawyers, I think, including Charlie Grubbing, who was the first president, I think, they were discussing the formation of San Diego Defense Lawyers.
Well, there you go. Then that's even more of an honor to have you today. So ladies and gentlemen, Ray Artiano. Ray, thank you so much for your time and presentation. We look forward to having you again next year, and you have a good day.
Thanks, you too.
Wait, I'm sorry. Look, a question just came in. Oh. There's a question last minute. It says, if a mediator limits briefs to just a few pages, what should you focus on challenging, liability or damages? Good question.
I would probably focus on the issues where you have a better argument. In other words, if you see this as a no liability case, then you're talking about liability primarily. But I would certainly hit both issues, and I probably wouldn't pay any attention to the mediator's limits. I don't think it's. I really don't think it's fair for a mediator to limit mediation briefs.
That's a good point. All right.
I've actually never seen that.
Yeah, I don't think I have either, at least for a mediation brief. All right. Without any further questions, Ray, enjoy the rest of your day.
Same to you. Thank you.
Thank you, everybody, for joining us. Take care.
Right,
bye.
Bye.